Morning, everyone. Thank you so much for joining us. Our litigation section at Miller Johnson has been really pleased to be putting on these lessons from litigators webinars throughout the year this year. And today we are going to be talking with you about document management and document retention. The topic or the title of our presentation is Don't Shred That, How to Manage Documents So You Don't Lose That Next Lawsuit. I have my colleague, Sara Weskalnies here. Sara is a litigation associate. She is in our Detroit office, also routinely makes a presence in the Grand Rapids office of Miller Johnson. And Sara and I work closely together on many litigation matters. I'm pleased to have her here with me today. And I am Amy Murphy. I'm a litigator at Miller Johnson. And document retention, while it may seem like a snooze, is actually one of the topics that I am most excited to talk to clients about after litigation ends, because we've often realized along the way during litigation that there are ways in which your document retention policy could be a little bit better. And we're ready to implement that once litigation is over, and we will get into that and why you need to wait a little bit later here. All right, so today's topics, we're going to touch on the purpose of the document retention policy for your company, why you should implement a document retention policy, what you should consider when you are creating that policy, how to determine that policy before litigation gets going, and what an effective policy often looks like. So Sara, do you want to get us going with the purpose of a document retention policy?
Absolutely, happy to, Amy. So our lesson today is about the importance of retaining documents in your business so that you are in the best position in the event of a litigation or investigation. But before we can understand how document retention can serve your company, we first need to discuss what a document retention policy is. A document management policy establishes and describes how your company expects its employees to manage company data. A written document retention policy will lay the ground rules for how your company will manage documents from the point of their creation all the way through their destruction. In other words, a document retention policy will allow you to determine which documents your company will keep and which documents your company, or for how long those documents your company will retain them. When thinking of document retention, there are certain documents that immediately come to mind. For example, emails, corporate records, and employee files. But document retention actually expands beyond just documents, those typical documents, and covers multiple types of media. You'll want your document retention policy to be media neutral, meaning that it applies to all forms of content in your possession. The types of documents that are listed within this slide are typical documents that a company would usually retain. But just to name other media documents that you might not be thinking of, you have, dictated media or meeting notes, audio files, videos, photographs, CDs. A good document retention policy will cover all different types of media, not just those documents that usually come to mind.
I just want to pause here for a moment, Sara, if you don't mind, because one that we've included on this slide that may surprise people are text messages. If you're at a company and your company issues mobile phones, then that information on the mobile phone is likely your property, or at least in your possession, custody, and control, a phrase that we will get into a little bit later. And so text messages become a record, potentially, that of your company, and a record that you might in litigation have to preserve and eventually produce. That is a particularly sensitive area because text messages themselves can be pretty sensitive. A text message chain often will involve some business communications mixed with personal information, and text messages are housed in the thing that carries all of our information, our phone, and it is not fun to have to go in and harvest text messages. But I think having kind of at the outset a policy that addresses company issued phones and the data that's on that phone, and making your employees aware of what that policy says, is a good start. So why do you implement a document retention policy? There are, obvious benefits, and we'll talk in more detail about federal and state law here, but in order to make sure you're complying with federal law, something I'm sure everyone listening to this webinar is interested in, you want a retention policy that looks to federal standards and state standards. And that's why sometimes it is helpful to get that policy kind of drafted and then run it by your accountants and your lawyers to let them know whether state and federal law that applies to your company are being complied with by that policy. Second in this list, and close to my heart, is saving on the costs associated with document preservation. In your routine work as a business, document preservation is an expense. It becomes, in some cases, astronomically more of an expense when you're in litigation, because the work of preserving documents, I should say collecting documents, preserving documents, producing documents, it's expensive. That is why discovery is such an expensive process. And that's the piece of litigation that, comes in the middle and takes up the most of the time in any given case. Right after the complaint's filed, but before a trial, you've got this long, arduous process called discovery. And there are other pieces of discovery, other components of it that can generate pretty significant costs too, like depositions. But document work, the collection, the preservation, the review, and the production of documents is often the driving cost in discovery. So having a retention policy that is informed by what discovery looks like in routine litigation for your company is important. And then you can avoid adverse consequences in litigation with a good document retention policy. We'll talk about that. It's really important because in litigation, and sometimes even before litigation, you have a duty to preserve certain types of documents. Your retention policy should also be informed by that duty. Documents and data are important for managing not just your business, but as I've just been saying, the potential for litigation or disputes. And so, as I mentioned, a good policy will help you avoid litigation costs. What I want to highlight here is that that item we flagged a couple slides back, the duty to preserve evidence and the risk of an adverse outcome in litigation. So key to your thinking about a document retention policy is the duty that you may have, the duty that arises to preserve evidence. That duty arises when you have notice that you have evidence that may be relevant to litigation or may be relevant to future litigation. So not simply when you are in litigation, but when you are foreseeing the possibility of litigation, that duty to preserve evidence is triggered. That's why, as I mentioned at the outset, the time to revise and implement a new document retention policy is not during litigation or when you're in the period in which you can see litigation on the horizon. Because at that point, you already have a duty to preserve, and you're not going to be in a good position to be making decisions about destruction of documents. The time to think about this document retention policy for any company that's listening to this webinar, for any employee, any executive, it may be now, because you may not be in litigation, you may not be foreseeing any potential dispute down the road. And so you're in a position to look at your policy and make changes to it. If you get served with a lawsuit tomorrow, it's going to be a significant period of time potentially before you can start looking at that policy again and making wise decisions to comply with federal and state law and to save on costs and to do what you can to preserve good arguments for potential cases, but also destroy in a systematic fashion the sorts of documents that you're entitled to destroy. The reason why we need to highlight this fact is because of a doctrine or really an important piece of litigation, especially in discovery, which is called spoliation. It's kind of a fancy old word that means that you're spoiling the evidence. The idea is that once that duty to preserve evidence has arisen, either because you are in the middle of the litigation or because you see it coming down the pike, your duty to preserve has arisen. You, at that point, are going to be under a microscope with regard to the decisions that you make to destroy documents. And if you either with intention or even inadvertently delete, destroy, alter in some way documents that are relevant or may be relevant to the litigation, a court is able to order sanctions against you. And those sanctions can be pretty severe. At the very least, we're talking about having your opposing party's attorney's fees covered by you, the fees associated with their filing of a motion on spoliation, and their fees associated with trying to recover the documents that you've deleted. But the sanctions can be even more significant in cases where the document is really important, or where the court finds that your conduct was intentional. And in those circumstances, you can even see a case dismissed. In between those two outcomes, a very common sanction is an adverse inference. That means that the court will instruct a jury in this case, and even the court can follow this instruction, that the document that you deleted was deleted because it was not in your best interest. It was probably favorable to the other side. And so the fact finder in your case is going to be permitted to presume that you've deleted something because it wasn't good for your case. That can be a pretty damning outcome. Adverse inferences are not where you want to be in litigation. We certainly like to avoid those, and you can do your part in advance of any case that comes up by having a document retention policy that systematically destroys categories of documents and does so without regard to potential litigation. Doing that will mean we've got the best chance of presenting your defenses or your arguments in the prosecution of your case without the possibility of severe sanctions. The other thing I will note briefly is that, and I mentioned this earlier, your obligation to produce documents in a case comes down to what you have in your possession, custody, or control. That is a common phrase we all throw around in the litigation world. And really it means the documents that the company either maintains or has the ability to retrieve, because the people who maintain them, if it's not the company, are under the control of the company.
So now
all right, what to consider when creating a document retention policy? I'll throw this one to you, Sarah.
Well, thank you, Amy. So now we're going to talk about what to consider. The first, and I think one of the most important things to consider, is what state and federal law applies specifically to you, your business, and the industry you're in. It's very important to know the state and federal law that's imposing record-keeping requirements on your company. You're going to want to make sure that while you're crafting a document retention policy, it's going to comply with all applicable laws, right? So some common federal laws that impose document keeping requirements are the Federal Insurance Contribution Act, the Fair Labor Standards Act, Equal Pay Act, and the Civil Rights Act. Those all impose record-keeping duties on employers. Michigan also has its own statutory record-keeping requirements for employers. That includes MIOSHA, the Family Medical Leave Act, Michigan Payment of Wages and Fringe Benefits Act. Those all have their own specific record-keeping duty requirements. Another thing that you should be cognizant of is that certain industries may have more minute and special requirements that wouldn't necessarily apply to all employers. For instance, in Michigan, licensed health professionals must follow statutory document retention policies as well, and that's set forth in the statute on the slide. So what else should you be considering? Well, one thing you consider is what it would be like to have no document retention policy at all. Although it would, maybe sound good in theory to have all the records of, your company, this approach is very costly and may not be as beneficial as it sounds. It would cost an exorbitant amount of money to store all that data that your company has on a day-to-day basis. Not to mention that the litigation costs you would incur to extract, store, and then have an attorney review all those documents during e-discovery, that would certainly drive up the bill. So a document retention policy will save you costs on two fronts. One, it's going to save you costs on storing the data on a day-to-day basis. And then it's also going to save you a lot when you actually have to extract that data in the event of litigation. So having an organized destruction of data will be much more cost effective than trying to save all these documents in the event you think that you might need them. So I know Amy mentioned this, but we're going to talk a little bit about preservation obligations again. As Amy mentioned, your preservation obligations begin when you're anticipating litigation or once it has commenced. You must know and abide by your preservation obligations to avoid a sanction from the court. As we discussed, spoliation is the destruction or failure to preserve relevant evidence, and it can result in costly sanctions. And as Amy mentioned, those vary all the way from, court fines to the unfortunate dismissal of your case. Two cases kind of stand out that demonstrate what the impact of preservation or following preservation obligations and not following preservation obligations. The first one is the Philip Morris case. That's a DC Circuit case. In that case, the court ordered Philip Morris to preserve all potentially relevant materials. But despite this order, Philip Morris continued to delete company emails that were over 60 days old. So this was part of like a document retention policy that it had. And it continued to delete these emails over a period of 2 years. So Philip Morris could have easily prevented this by just stopping its routine document destruction. But it did nothing to preserve its preservation obligations or follow its preservation obligations and to ensure that those were being executed effectively. So what did the court do? In light of that, in light of their inaction, it ordered and fined a $2.75 million fine for failing to prevent the destruction. And what's notable about this is that there was no bad faith in this instance. It was just pure inaction on the part of Philip Morris. So that's kind of a horror story to keep in mind when you're considering whether or not you're following along with what you need to be doing, especially under court order. On the flip side, there's the Pradaxa case. In that case, the Pradaxa was not subject to any litigation sanctions because its preservation obligations hadn't quite kicked in yet. It had its document retention policy still in place, but because it knew when its preservation obligations were to start, its routine destruction of documents didn't warrant any sort of sanction because it was doing so properly. So how long should you be retaining your documents? This seems to be, the question of the hour. As I discussed, it's super important to know the federal and state laws that apply to your business. That is critical when you're trying to implement an effective document retention policy. Another big part of that is knowing your business industry to make sure if you know that there are any special document retention requirements that you need to be following. Another thing that you should consider is the risk of litigation that your company may face. Is it likely that a shareholder dispute will arise, or employment litigation or contract litigation? If there are common litigation suits in your industry, you may want to keep certain documents a little bit longer than the standards or common standards suggest, and especially if you know that those documents may be critical and important to that dispute. So this slide discusses common document retention timelines. We have them organized in 3 different buckets. There's the 3 to 4 year bucket, which applies to some employee personnel files and employee applications. We say some because there's certain rules under MIOSHA that require certain records. I think it's exposure records and medical records as defined by the standard that may be included in an employee personnel file, and those are required to be retained during the duration of the employee's employment plus 30 years. So that obviously extends past that 3 to 4 year standard that we suggest in the slide. So that's something to be aware of as well. We have the 7-year requirement, which applies to bank statements, invoices. That's pretty typical for tax records. And then in the permanent bucket, we have documents that we recommend that you retain for life. Those include audit reports, financial statements, your corporation's documents, legal records, trademarks, and as Amy probably wants to touch on, most importantly, insurance policies.
Yeah, thanks, Sarah. I'll say too, just knowing that this slide is in front of you all and you're looking at it, these are really just common timelines you might see, but it really will depend on your business. And so that's why, and not only that, but where your business is located, right? What state law applies, which federal law applies, what's happening in your industry. 3 to 4 years may be too short for many of your files. 7 years is a benchmark you see in lots of different industries. And I think it's driven in large part by the 7-year standard that's often recommended for your tax records. And if it's something as important as tax records, right, if you've got to keep those for a recommended 7 years, then lots of other things would fall into that sort of bucket. And so you see 7 years a lot. But as Sarah mentioned, there are lots of documents that we really would stress the importance of keeping for as long as you can. And these aren't the big data dumps like email or every single, bank statement you've ever received, but key documents to your company's business. And one of those is insurance policies. It's amazing. I've been involved in a number of cases where we're trying to figure out what insurance policy applied for what time period and covering what claims. And without the even these expired policy documents, it can be pretty difficult detective work to uncover. So keeping even your expired policies, the key policy documents for them, I would recommend is a good idea, because insurance is so often a piece of the puzzle when you're trying to figure out whether you want to litigate, whether you're going to defend the case, who's going to defend the case, whether any of it's going to be ultimately covered, right, in terms of defense costs or a settlement or a judgment. And having those policies at hand, not having to go fishing for them is really helpful. So, I would advise thinking about putting them all together in one place, one cabinet. If you've got a paper filing system, one electronic folder that is kept kind of securely and isn't routinely sort of opened and closed, where you can alter those documents without you realizing it. Just keeping them kind of stored away electronically or in paper format is a good idea. Contracts we threw into this category. And of course, you can sort of make judgment calls about the kinds of contracts that are so short-term or routine that it's unlikely there's ever going to be litigation coming out of those. But key documents associated with your key contractual relationships, probably a good idea to hold on to for quite a while. And why I say that is there is, from time to time, we're involved in litigation where we are peeling back layers of the onion, looking at a contractual relationship that may have unfolded over the course of decades. And the more, you have the actual contractual documents, the executed versions of your contracts, the better it is for putting together the story and doing so effectively and cost efficiently. Sarah, on the previous slide, noted that one thing you'll want to consider are statutes of limitations and statutes of repose that govern the ability to file claims in the states where your businesses are located. And that is another great point, right? In Michigan, the general statute of limitations for breach of contract is 6 years. Well, let's imagine you've got a relationship and blip on the radar, something happens today, it, becomes a dispute and you're working on it from a business perspective to try to avoid litigation, but it's possible it's going to go to litigation. Well, it's possible it's going to go to litigation even 6 years down the road, which is a really long time from today. And when we're actually litigating that case, maybe the case gets filed in a year, maybe in 2 years, maybe in 6 years. We're not only looking at the past 6 years, we're hoping in litigation to be able to piece together a story for the court, for the ultimate fact finder about what that contractual relationship obligated each party to do, where the breach occurred. Was there a breach? Did the other side have a duty to mitigate and comply with that duty? And a lot of the story precedes the breach. So thinking about a timeline in which a contract could matter isn't just thinking about the statute of limitations in the state. It's thinking about how long of a contractual relationship do you have with this party, and how important is it that you be able to tell kind of the beginnings of that story too. And I would say often in litigation, I'd rather have all of that than not. So for your key contractual relationships, especially in industries where you know those contracts are often litigated, think about keeping those for a much longer period of time and storing them in a way that ensures that they're not inadvertently deleted.
So email data, this is pretty important because, as many of you know, email data is going to make up the bulk of the documents that are going to, be in your possession, right? Say you have a company that has 80 to 100 employees, and those employees are sending emails from the day to day over a course of years. That's going to end up being pretty close to over 200,000 emails. So it is extra important that you have some sort of system in place that's routinely and organized fashion destroying documents. As litigators, we know that email documents make up the largest portion of data in e-discovery. You have to have someone review those documents. So it's even more important that you're not holding on to those email data longer than you have to. Something else to consider is how expensive, I know we touched on this, but how expensive it is to maintain email data without an archiving solution. One thing to consider is that it's actually, pretty easy to come up with an archiving solution through, I think it's like Microsoft Outlook or some other system. It can impose rules without having to require a whole lot of work on your part. It's something you can consult with your IT team, and they can put something in place that will routinely destroy documents after, the timeline that you put forth. And then as far as how long you should be retaining emails, that really depends on, the laws in your industry. I think typical retention policies may recommend between 3 to 7 years, but that's something very specific that you're going to want to work through with your own company.
All right, so determining the right policy before litigation. As Sarah mentioned, you can work with your IT team to meet company needs. You can work with your various counselors, accountants, lawyers, internal colleagues who know the needs of the business to determine the appropriate retention timelines. And then it's also really important that your policy define all of these categories of documents and also define a litigation hold. Much of the suggestions in these slides are about common timelines we see, general standards for when you retain them and when you can destroy. But all of that depends, again, on there not being an ongoing duty to preserve evidence. When that duty arises, it's important to issue a litigation hold. A litigation hold is a notice that requires a company, including its employees, including sometimes its contractors, including board members, to preserve data that may relate to an action that's been filed against the company or that you foresee being filed against the company. It can also be important to issue a litigation hold when a company is under investigation or where there's where you're anticipating that the company is going to be part of an investigation. And the idea of the litigation hold, and we draft these routinely. We help companies, write them the way they should be written given the type of action you're foreseeing. But the key is to prevent the destruction of evidence, prevent spoliation, remind your IT staff that they need to turn off automatic deletion. So you're not in the situation that Philip Morris was in with a fine of $2.7 million for just failing to turn off, flip that switch and avoid inadvertent deletion. And then to avoid, for your employees, it's important for them to kind of think through, read the litigation hold and think through the ways in which they may, without even thinking about it, delete documents day to day and not do that anymore, right? Not throw things in the recycling bin on the desktop if they relate to litigation. And often we use a broad rule of thumb. So if if it's, if it's a hard call on whether that document can or cannot be deleted, we'd recommend just holding on to it for the period of litigation or the period in which your duty to preserve evidence is in place. The right policy for your company won't be something that we can describe as a one size fits all in the course of this webinar, because as Sarah mentioned, there are so many factors that go into what your retention policy needs to look like and what it should look like given your industry. But some steps to think about as you're preparing your policy or you're coming back to it to revise it is to know the documents you have, classify them, create or revise your policy so that it is litigation neutral, and implement that policy. And we'll get there, but someone on this webinar has already asked a question about how effective is the document retention policy if you're not following it to the letter, you're not implementing it. The answer is going to be that it's probably not effective in terms of being able to show in litigation that the policy that you have is one that is allowing for routine and systematic destruction of documents, doing so without regard to the litigation that you're in the middle of, and being implemented in a way that the court and your opposing party can trust that that policy dictated what happened in that case. If you're not able to produce that policy and be confident that it's being applied, it makes it a little bit harder in litigation for us to stand by that policy and say that the reason why certain documents don't exist is simply because the policy applied in its routine and systematic fashion. So know your documents is step one. This is harder than it sounds, harder than you can even describe in a slide, because we all live in an electronic world and so much of our routine work occurs over email, in voicemail messages, in some cases over Skype and Snapchat and WhatsApp and these social media platforms that businesses are using for instant messaging from time to time. Slack is another example. So it's important to sit down with your IT team, with other key members of your business, and think about what documents you have and where they are. They could be in a cloud, they could be on your server, they could be in an old filing cabinet in the back of your warehouse, and making sure you've got tabs on those is key. Then you can classify the documents. And we've talked about many of the points on this slide already. I'll just note a list of documents that are important in disputes. And so when you're classifying them, think about these sorts of documents as more long-term retention documents. These are executed versions of contracts, performance reviews, timelines that you've created as you're anticipating the possibility of a dispute, insurance policies we've mentioned. Here's a good one: records that really summarize the key decisions that your company makes and the deliberative process you went through. So these are things like your board meeting minutes, authorizations, reports that are generated when you're making a key decision. Organizational charts is another important category to hold on to. Often organizational charts help us in litigation to reduce the number of people that need to be involved in a dispute. If we can prove through your organizational chart that certain departments are just not relevant to the dispute, or certain affiliated companies really shouldn't be brought into the mix, that organizational chart can be helpful in demonstrating that and reducing the discovery costs. On a similar note, keeping lists of your employees, the executives and the board members of your company, also can be critical to sort of reducing in litigation the number of people who truly need to be subject to document requests or sitting down for a deposition. All of those are burdens on your company, and keeping a good list of the key players at your company will help us analyze who are the important people that we do need to depose, we do need to collect from, and who are the people that we're going to be able to persuade the other side. Do not need, leave those folks alone. They're not relevant to the dispute. So we've got examples here of ways you can organize your data into groups of things. And this is similar to slides we talked about previously. What are the kinds of documents that you must keep? What are documents that you don't have to keep because there's no legal requirement, but you want to keep them because they either are valuable to the ongoing needs of your business, or they're going to be the sorts of documents that support your arguments, your defenses in litigation that you can foresee might come up with a key contractual player that you work with, or perhaps with an employee, perhaps with a board member, perhaps with a key executive. And we mentioned this at the outset of this section of the webinar. It's important that your policy be litigation neutral. And that means don't make decisions based on possible litigation you foresee down the road, or litigation you're in the middle of. When you're in the middle of litigation, when you're anticipating litigation, it's not the time to be revising your policy or making new decisions. And often, as we've mentioned, you're going to have a litigation hold in place that prevents you from doing a lot of the more routine destruction you would otherwise be doing under your policy. But ensure that your policy doesn't suggest that you've got a bucket of documents that you delete because you don't want anyone to be able to see those. That's not a policy that's going to be defensible, and the policy itself is discoverable. Often we are producing in litigation your document retention policy as proof that you do right in your decisions about when to delete, how often to delete, what to keep because of your compliance with federal and state law. It's also the case that occasionally there will be a deposition of, we often call it like a 30B6 witness. And this is someone who's brought in to represent the company and describe the company's decisions and policies. One topic often addressed in those depositions is document retention. And so someone is going to be speaking for that policy. So make sure the policy is defensible and reads well, isn't full of language that will be called into question in the litigation. And then one of the most important steps is once you've done the work of creating this policy, you've looked to federal law, you've looked to state law, you've thought about statutes of limitations and what your industry standard might be, implement the policy. Make sure you've got ways to audit that it's being applied and applied neutrally. Make sure your employees know what that policy is and that it's enforced neutrally with regard to employees. And if you, from time to time, do make important changes to your policy, document those. A document retention policy is only as good as the paper you find it on. So if your document retention policy isn't actually recorded or hasn't been updated, the document itself hasn't been updated to reflect what your policy is, it's not going to be a document we can rely on in litigation to help keep your costs down.
So now that we've kind of talked about what a document retention policy is and why you should have one, now we probably want to look at what an effective policy will look like. So what does an effective policy do? An effective policy is going to manage documents that must be maintained in accordance with the law. Like we said, following state and federal law that apply to you is very important. And you also want to make sure you're keeping documents that allow your business to function effectively. So that would be number one. We also want a good policy to lay out the schedule of the systematic destruction of records in accordance with its guidelines. It's kind of what Amy mentioned. You want to make sure that the policy operates the way it reads. Then you also want to make sure that it's effectively destroying the documents, which kind of goes into the same thing, and it's doing so under the terms that are set forth in the policy. And then finally, you want a group, a team, it could be your IT team, but something that's in place to monitor and audit the company's execution of the program. This kind of relates back to the Philip Morris case. If you have someone who's overlooking your document retention policy, making sure that it's turned off when your preservation rights have kicked or obligations have kicked in, that's something that you need in place to make sure that you're covering all those bases and checking those boxes.
All right, I'll just touch on one more question that we received during the webinar. And this is a question about email retention when the the attachment to the email is perhaps a fully executed contract. You want to keep that fully executed contract, right? You may not have a legal obligation to do so, but you can see that it's important to keep that fully executed contract. The question was, do you have to keep the transmittal email? Here's one interesting thing to think about. Sometimes in litigation over a contract, a question arises whether the contract was actually received. And so there are cases in which the email transmission could be important. But if you have a fully executed contract, you've got a copy that your company has signed and every other party to the contract is signed, then there's unlikely to be a dispute about transmission and receipt of the contract, because you're going to be able to show that each signature is a signature of the party, a party to the contract. So there are occasions when it's helpful, and we're grateful that the email transmission or the fax transmission, people sometimes still use faxes today, is still recorded somewhere. But I think you're doing a good job if you have fully executed versions of your important contracts kept in a secure place, so that if litigation arises over that contract, we've got not just a version that's executed by your counterparty, we've got the version that's executed by everyone with dates, and it's going to eliminate questions about receipt of the contract. That's a great question, though. Before we part, and we are grateful that you all sat down with us this morning, grabbed your coffee, and talked to us about document retention. Again, not the flashiest of topics, but one that really is important in day-to-day business as well as in litigation. We thank you for joining us. We have a couple of webinars coming up for this Lessons from Litigators series at Miller Johnson, and I just want to highlight those quickly. On September 2nd, at our usual 8 a.m. slot, we've got Catching Hands in the Cookie Jar, Effective Internal Investigations. Our colleagues, Matt Beccari and Lacey Weskalnies, are going to talk about what it looks like to do an effective internal investigation in your company when an issue of potential wrongdoing has arisen. And then 3 or so weeks later, September 23rd at 8 a.m., Matt Beccari will be doing another webinar for us, what to do when the government knocks on your door. So in September, if you've got questions regarding potential and effective investigations or government investigations, please feel free to tune in. We look forward to seeing you again soon. Thank you so much.
Thank you, everybody.